All right, welcome back. Uh, I've got a fun one for you today. That oh boy, that this one's going to be good. Trust me. So, for those of you who are new here, I'm Joe. I'm an attorney based in Utah, licensed in Utah, and I'm quite satisfied today because my Utes just earlier tonight beat Florida in the sports ball. So, go Utes! I'm happy. Um, but So today we are headed to St. Me County in Michigan to Judge Middleton's courtroom. So let me set the scene. Basically, we've got a sovereign citizen who this is at least his third court appearance. It's the this is the first time covering. The others are all over. I saw them on Law Talk with Mike, so go check them out there. They're good. Basically, Kirk Jensen, sovereign citizen, and in the first appearance, Debbie Davis, excellent prosecutor, offers him a great deal, but says, based on the information I have, if you don't take the deal, we're going to amend it to a felony because apparently you presented a fictitious identification. So it wasn't just driving without identification, which is a misdemeanor. It was fictitious identification, which is a felony. The moron didn't take it. So he was charged with a felony. And basically, this hearing is his last chance to take the misdemeanor because after this, he's going to be bound over to circuit court and Judge Middleton will lose jurisdiction and we'll lose video, unfortunately. But yeah. So, why is this one so good, though? He goes full Blandino. We have in Michigan Kim Blandino 2, Sovcit Boogaloo. It's wild. And why can I confidently say he went full Blandino? Because there's a federal lawsuit. And I will show that to you after the video. So you're going to want to stay tuned until the end. But with that said, let's jump into the video.
Jensen here, who's unrepresented. Mr. Jensen, would you come up and have a seat? Josh, you kind of inherited this. Mr. Jensen was originally charged with traffic violations. The matter was set for a jury trial for August 16th, I believe it was. We had summoned jurors and we were ready to proceed. Earlier that week, I believe August 14th, Mr. Marvin filed a felony complaint based on the same set of facts. So the matter was set for a pre-exam conference. Mr. Jensen has made every court hearing, but he did express that he wants to represent himself. I offered to appoint counsel at each stage of the misdemeanor proceedings, and again in this case, but he declined. So, Mr. Jensen, you still wish to represent yourself in this matter?
I wish to have this case completely dismissed.
Wouldn't we all? I mean, if I'm ever charged with a crime, yeah, I want it dismissed. If not, I want a lawyer. I mean, I am a lawyer, but I'm not dumb. So I want someone else who's licensed to practice law to speak on my behalf. Because guess what? I have the right to remain silent. And that's one of the reasons why even lawyers have other lawyers represent them. Because what my lawyer says, I mean, it can harm me, but it can't be held against me. Anything I say can be held against me.
Well, everybody feels that way. Everybody else who wants their case dismissed, raise your right hand. Yeah, that's unanimous. So that's not up to me. But the question is, I'm willing to appoint counsel for you, but you've represented to me at each stage you wish to represent yourself.
I do not wish to have any counsel.
All right, well, then let's talk about where we are. Where's the complaint? The complaint alleges that on or about April 6th in Lockport Township, that you did obstruct justice by preferring a counterfeit U.S. passport and counterfeit international driver's license at the time of a lawful traffic stop, an attempt to avoid criminal liability for driving without a license.
And we're going to get to see poor scans of said fictitious documents.
The way that is charged, it is a felony punishable by up to 5 years imprisonment and a fine of up to $10,000. The second count is possession of a reproduced, altered, counterfeit, or forged chauffeur's license. Operator's or chauffeur's license. That's a misdemeanor punishable by up to a year in jail and a fine of up to $2,000. Count 3 alleges that you had no valid operator's license, plain old no ops. Are also charged with a civil infraction of no proof of insurance.
And I object to those. I object to that being labeled as counterfeit on all of those documents.
All right.
I mean, but that's what the charge is. The jury gets to decide. That's a factual decision. You don't get to object to the facts. You can object to it being admitted, whether it's admissible or not. Spoiler alert, it will be. But Judge Middleton isn't making a determination of whether it's fictitious or fraudulent or whatever. He's just reading the charges.
Mr. O'Bear, do you have any instructions here or a plea offer? Or?
So the offer would be if the defendant wanted to plead to count 3, operating with no license, it's the 90-day misdemeanor. We would recommend fines and costs.
And that's a phenomenal offer. I mean, like, generally, I'm going to recommend, if you're not guilty, don't take the offer. Take it to trial. I mean, obviously, because if you're not guilty, technically they're not supposed to take a guilty plea from you because there's got to be a factual basis. They might take a no contest, and I'm sure Judge Middleton would accept a no contest here. But if the prosecution is able to meet their burden, which here they're easily going to, this is a slam dunk. Easy prosecution. Take the deal. It's a no-brainer, especially when he says, we're only asking for fines and costs, no jail time.
I object to that, and I will not consent to that either.
You object to an offer being made. Make it make sense. You object. Yes, you can decline the offer. That's fine. That's your prerogative. But objecting to an offer.
All right, let me unpack that a little bit. All right, you're charged with a felony and you're charged with possession of a false or forged counterfeit license. They're also charged with no proof of insurance. Prosecutor would dismiss all of those charges if you plead to no valid operator's license with a fine and cost. You may be the first person in my 21-year career that objects to having all the felony charges dismissed for a plea to a $200 fine. Nonetheless, you object.
I object to the fact that it's been labeled as counterfeit.
All right, well, they're just willing to dismiss that charge. The allegation in count 3 is that you are operating a vehicle on a public roadway without having a valid license, sometimes called no ops or no valid operator's license. It's under 257301 of the Michigan Traffic Code. It's punishable by up to 90 days in jail and a fine of up to $100. It carries 2 points and it goes on your driving record. If you plead guilty to that charge, I'm going to fine you $225. I'm going to give you time to pay it, and the matter will be done. If you don't wish to plead to that, we're going to have a preliminary examination next Wednesday, where the prosecutor will attempt to bind you over to circuit court on felony charges and continue the matter for a felony conviction with potential prison sentence. So his offer is to just be done with all of it for a plea to no valid operators. That's, frankly, was kind of surprised by the generous offer, but that's what it is.
Frankly, I am too. I mean, like I said, it's a slam dunk prosecution, even on the felony. So, I mean, why give such a generous offer? You don't need to. It might be the standard offer that they would give regardless, but they don't need to. They don't need to give any offer. You're not entitled to an offer. The prosecutors can just say, you know what? We view you as a nuisance. We view you as wasting our time. So no offer. We're taking it to trial, period. Done.
Is. So our options are to plead to having no valid operator's license. You could even plead no contest.
Told
You
you.
can plead no contest. You don't admit what happened, but you also don't deny what happened. You allow or accept that a conviction will enter. You and I have a fundamental disagreement about what it means to operate a vehicle or what it means to travel. But if you want this matter to be over with, you can enter a no contest plea to no valid operator's license. If you want to reap the whirlwind, we can have a preliminary examination next Tuesday afternoon.
What he's saying there is, if you want to take this to trial, we're going biblical on you.
Regarding the matter. What would you like to do, Mr. Jensen?
I don't accept any of that.
All right, the matter will be set for prelim.
And just to make it clear, this would be the third time that a charge of no operator's license has been levied against me, and I'm standing against it because those documents are valid. And
So it's his third time being charged with it. It's why give him such a generous plea offer when he hasn't learned his lesson the first 2 times? He still has it in his head. These are valid documents, but they weren't valid for Kim Blandino. They're not valid for him. And Judge Middleton has less tolerance for this nonsense than the Justice Court, the Clark County Justice Court judge. It boggles the mind. This guy just does not get it, and he will not get it until he serves jail time. That's a 5-year sentence hanging over his head. He's not going to get 5 years, but the potential is there. And he's just take him to trial.
object to them being
Well,
labeled as
we'll
counterfeit.
find out next week. So that will be Tuesday, September 5th. At 1 p.m. Prelim. All right, your bond is continued. You're free to go.
And just a reminder of the civil case that is ongoing and those who are named in that, yourself and Mr. Marvin as well.
So, spoiler alert, as of the time he said, just a reminder of the civil case that is ongoing, you may have noticed the emphasis on is ongoing from Mr. Jensen. As of the time he uttered it is ongoing, it wasn't.
Just to make sure that
Which civil case is that?
civil case, the notices, and all the recusals and everything that's been filed into this case that I've been filing in. Just to make note of that, that it is, on the record.
Well, let's take a look. Oh, you filed a August 28th, which is yesterday. I got this. I didn't see it. Objection to the report and recommendation in the matter of civil case. You filed this in federal court?
This was done in a federal court, has a federal case number on it. And all the defendants are listed
Not really.
All right.
along with the notice.
Oh, it's great pleadings. It cites Abraham and the Book of Nations and a bunch of other jabberwocky.
now that for those of you who couldn't tell was sarcasm from Judge Middleton when he said, now that's great pleadings. It's not. It's bad. And like I said, Mr. Jensen says, well, you're listed as a defendant and the prosecutor's listed as a defendant. We'll find there are no listed defendants. Not really. But once again, that's spoiler alert.
But it has been filed in the federal court. All right, that's all a matter of record. It's in the file. And you've even got Hebrew letters in here. Okay, I'll see you next Tuesday at
See you next
1
Tuesday.
o'clock. Yes? Yes?
I'm Mr. Jensen's transportation.
Yes.
And on the 5th, my wife has chemo, and I have to take her to that. Is there a way that we can put it off to the following week? If that's all right with Mr. Jensen?
That would dump the matter on Judge Pattison, which I'm sure he would greatly dislike. So,
It's almost like, no, court is Mr. Jensen's obligation on Tuesday. That he can walk for all Judge Middleton cares.
I'm sorry, but we'll leave it for that day.
It would be the 6th that would work.
I'm open to.
I don't know why my computer decided to autoplay there, but I wasn't done with my point yet. He can walk. He can take an Uber. He probably can't afford an Uber, having seen his financial disclosures, but you're not the only ride. You may be he might be the only sucker willing to give Jensen a ride, but it's like there are other options. You are not, the only people on the face of the earth. You, Mr. Jensen, and Judge Middleton and the prosecutor. There's 8 billion people. He can find a different ride. He can ride a bicycle. He can hitch a wagon and, drive a team of horses. He just can't drive an automobile or a motorcycle, I guess, too. So
Any date at this point.
We schedule things at certain times and everything affects everything else. So no, it's next Tuesday. You could be done with this for $225 And so will be next Tuesday, sworn testimony in court regarding this matter. Do you wish to not have counsel? And we'll continue that. I'll make further record. At this point, I'm declining to recuse myself.
The right call.
This is just a straightforward matter. All right, next Tuesday, 1 o'clock. You can make your way here somehow. Do you need a bus pass? I'll give you that.
Oh,
All right, you're free to go. Kirk Jensen here.
and like Judge Middleton says, this is a straightforward matter. It's a slam dunk for the prosecution, especially. I mean, I've said this time and time again, covering both DeCastro versus LVMPD and Floyd Wallace versus LVMPD. Although with Floyd, since he wasn't prosecuted, it doesn't hold as much weight. But especially with DeCastro, delete laws. You sue in federal court before the criminal case is over. And speaking of which, the criminal case for delete laws is coming up in 11 days as of the time I'm recording this, September 12th. So if you sue in federal court, you're probably making admissions in the criminal case. And this moron, Kirk Jensen, is making admissions for his criminal case. So let's switch tabs here. We've got court listener, and we have, like I said, Jensen versus unknown parties. Who isn't listed as a defendant? Judge Middleton, the prosecutor, the police officer, unknown parties. I mean, let's even click parties and attorneys. Unknown parties 1, 2, 3, 4, 5, 6. And Kirk Jensen, represented by Kirk Jensen. So, oh, come on, don't do that to me. There we go. So yeah, let's take a look at the main document, which usually would be the complaint, but yeah, this isn't a complaint. Let's make that bigger. I guess that's as big as we can. There we go. So we have Kirk Edwin Jensen, Reign citizen. Like I said, Kim Blandino is also a Reign citizen. Reign of the Heavens. NAC address 70 PHZ P5FJ2. No idea what that means. And this is an alien tort claim as defined in blank USC section 1350, aliens action for tort. Because he's not a US citizen. He's a Reign citizen. So he files an alien tort claim. And comes now Kirk Edwin Jensen, hereinafter claimant, a Reign citizen being competent to testify and being over the age of 21 years, after first being duly sworn according to the law to tell the truth to the facts related herein, states that claimant has firsthand knowledge and belief that these facts are true to the best of claimant's knowledge and belief, and for the purpose of this alien tort claim, the Crown shall include the following persons, all variations of the person: Sheriff's Department, a Department of County of St. Joseph, DUNS number, blah, 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 all variations of the person, St. Joseph County Court, all variations of the person, State of Michigan, because the State of Michigan's a person, apparently. The person, State Bar of Michigan, all variations of the person, Government of the United States, Federal Corporation doing business as U.S. government, located in the District of Columbia, as evidenced in 28 U.S.C. 3002-15A, all districts, states, hereinafter states, and of the U.S. government, and the person, City of London Corporation. The City of London Corporation. You can't make this up. Okay, get it together. Exhibits within this alien tort claim, hereinafter claim by Kirk Edwin Jensen, Rain citizen, are as follows. And we'll look at some of these exhibits after this document. So, Exhibit 1, evidence of claimant's citizenship within the reign of the heavens, a set apart place, in the form of the Constitution for reign of the heavens, first page and signatory page within said Constitution, pages 7 and 8 within this claim. 2, alternate evidence, claimant's private membership association, hereinafter PMA, in the form of an international translation of national driver permit issued in conjunction with a national driver permit under the authority of the Department of Transportation through the Office of the Secretary of State for the Government of the United States of America, Office of Deeds and Recordings, hereinafter DOT, page 9 within this claim. Passport image not available. Currently in possession by St. Joseph County Sheriff Deputy for St. Joseph County Sheriff's Department. Okay, so we won't see the passport image. We'll just see the fake driver's license. Sorry. But the Secretary of State and the Department of Transportation of the Government of the United States of America do not issue any driver's licenses. They're entirely issued by the state. Exhibit 3, electronic mailing address verification of claimants renouncing Lucifer and his kingdoms of the world, page 10 within this claim. Okay, so that there's going to be kind of an when we go back to the docket, it's going to say Exhibit 9 is missing and go straight to Exhibit 10. But these are all included as one document, and the court clerks split them out into individual exhibits when uploading them into Pacer. So, Exhibit 4, North American National Party, hereinafter NANP, Political Party Affiliation Declaration, page 11 within this claim, link to claimant's NANP legal notice of proclamation of existence, provided herein. Proclamation of existence. I exist. Did you hear my proclamation? And then we have the notices of arraignment 1, 2, and 3. And then Exhibit 8, the debt of the U.S. government as of the 107th day in the year of Yahweh, 6025. Translated as the 4th day of July, 2023. So he's a young earth creationist. The year of Yahweh, 6025. Exhibit 9, the debt of the state of Michigan as of the 107th day in the year of Yahweh, 6025. So, like I said, that the clerk accidentally combined exhibits 8 and 9. So we'll forgive the clerk for that because it's all nonsense anyway. Then we've got 2 notices to appear. 12, non-statutory abatement filed with the clerk of the St. Joseph County Court on the 102nd day in the year of Yahweh, 6025. And then the state of Michigan uniform law citation, basically his traffic citation. So the charges by claimant within this claim shall reference the codified law of nations and the International Convention on Civil and Political Rights, hereinafter ICCPR. And now the claim. Claimant is a citizen and one of the permanent population of the reign of the heavens, a set-apart place on earth, and the creation of claimant's God of Abraham, Isaac, and Jacob, hereinafter Hebrew, and a servant of Hebrew, or Hebrew's son, Yahushua, the Messiah, hereinafter different Hebrew, and a signatory to the new constitution for the reign of heavens as of the 52nd day in the year of Yahweh, 6025, otherwise known as May 10th, 2023, evidenced in Exhibit 1. Claimant recognizes that, I'm assuming this one is God and this one's Jesus. So claimant recognizes that Jesus was tortured, died, and resurrected, and is claimant's king and savior, the one and only sovereign of sovereigns, and claimant's sovereign authority on earth. Jesus proclaimed the only way/religion for salvation, evidenced in scriptures. John 14:6 stated herein, Jesus said to him, I am the way and the truth and the life. No one comes to the Father except through me. And claimant is a follower of his established way and the truth and the life. And this is just preaching. It's, I get so annoyed by it. So let's skip ahead a little bit. So under the sovereign authority of Jesus, claimant has entirely renounced Lucifer and his kingdoms of the world all the way back in 2017, including but not limited to associating with members of the Luciferian Masonic Bar Association. Apparently, I'm Luciferian and Masonic. Wow. So the Bar Association factions of Inner Temple, Middle Temple, Gray's Inn, and Lincoln's Inn as inns and temples of court inside the Luciferian Masonic Temple Bar Gateway of the meets and bounds of the Luciferian Masonic City of London Corporation. So the Inner Temple, Middle Temple, Gray's Inn, Lincoln's Inn, and the inns and temples of court, those are entirely to do with barristers in England. Nothing to do with the bar associations in the United States. Now, some of you may have heard, I know lots of you subscribe to Artie's Corporate Fiction, and whenever Sovereign Citizen says, You belong to the Bar Association. You answer to the American Bar Association. And Artie says, no, I don't. I've never been a member of the American Bar Association. I'm licensed, he is a licensed member of the New Jersey and New York state bars, regulated by the state Supreme Court, although in New York, the Supreme Court is the trial level court because they're weird. And it's not the Bar Association, it's the bar, the New Jersey State Bar. Here in Utah, the Utah State Bar. But like I said, regulated by the state Supreme Court. But I am a member of the American Bar Association. It's a cheap way to get continuing legal education online. So, said members utilize Luciferian Roman canons of Holy See, evidenced in SBM's Michigan Code of Judicial Conduct. Claimant recognizes members of SBM as members of a bar association faction of the Inns and Temples of Court within City of London Corporation, and claimant recognizes that any religion, including but not limited to all factions of the Masonic religion, not acknowledging Jesus as King and Savior, or any act of operating without acknowledging an established religion, is an act of duality considered Luciferian and of the world. And claimant recognizes that County of St. Joseph is a political subdivision of the political subdivision state of Michigan. The state of Michigan is not a political subdivision. The state of Michigan is a sovereign state. Period. It's in union with the other states to form the United States, but it is not a political subdivision. It's a dual sovereign. The United States and the individual states are dual sovereigns. Kind of like the UK and England, Scotland, Wales, and Northern Ireland. They're kind of separate, but not. But evidenced in Law of Nations, Book 1 of Nations Considered in Themselves, Chapter 4 of the Sovereign, His Obligations and Rights, Section 40, of his representative character and foreign to claimant's political affiliation and society, evidenced in Exhibit 4, page 11, within this claim. Therefore, County of St. Joseph is a foreign political society whose members are exercising the administration of a political authority foreign to claimant's political affiliation and society under the authority of Jesus. Claimant operates with the credentials of claimant's private membership association, Kirk Edwin Jensen, PMA, hereinafter PMA, evidence in Exhibit 4, page 11, within this claim, with credentials currently in possession by St. Joseph County Sheriff for St. Joseph County Sheriff's Department. Claimant's credentials were taken and not returned to claimant, therefore continuing to arbitrarily traffic claimant's PMA and or claimant to a U.S. Postal Service address as a resident / quasi-citizen / ward of a state of Michigan. Ward of a state of Michigan. Got to get that right. Claimant was given notice of arraignment as evidenced in Exhibits 5, 6, and 7 within this claim, signed by deputy. Claimant did not consent to nor give a signature for any contractual sin alleged by the people of state of Michigan upon appearance for arraignment. Okay. Apparently my computer is haunted. Hopefully that's the end of the haunting. Now? maybe it was the mouse pad on the laptop. My headphone cord was laid on it. I'm guessing that it was just hypersensitive to that. I'm hoping. Because otherwise, it could be Kirk Edwin Jensen and his government haunting my computer. Or I hope not. And I lost my place, so I'm just going to start here. Claimant does not associate with trafficking in persons / persons. Claimant recognizes the employment of Deputy Sheriff Judge Prosecutor 1, Prosecutor 2, and State of Michigan as a political power foreign to and renounced by claimant prior to injuries incurred upon claimant by that same list. Claimant recognizes and renounces the fiat currencies of the world as subject to private banking institutions, including those banking institutions of the private Federal Reserve System and investment companies whose owners associate with Luciferian banking institutions within the metes and bounds of City of London Corporation. Claimant recognizes that the Federal Reserve note is a promise to pay, or credit, wherein the U.S. government and state of Michigan are outstandingly indebted to another, evidenced in Exhibit 8 and Exhibit 9 within this claim. State of Michigan is already indebted to another, therefore claimant owes no gratitude indebtedness to the outstandingly indebted. So if I owe money to Visa, MasterCard cannot claim I owe them money too, by this logic. Apparently. Because I can only be indebted to one creditor by Mr. Jensen's logic. Let's skip to the next claim. Or charges. As evidenced in the non-statutory abatement filed with the Clerk of St. Joseph County Court, Exhibit 12, claimant hereby charges Deputy for St. Joseph County Sheriff's Department, a Deputy of County of St. Joseph, Kevin Brooks, hereinafter Deputy Sheriff for St. Joseph County Sheriff's Department, a Department of County of St. Joseph, Mark Lillywhite, hereinafter Sheriff, State Bar of Michigan, hereinafter SBM, members Judge Jeffrey C. Middleton, hereinafter Judge, Prosecutor David Marvin, hereinafter Prosecutor 1, and Prosecutor Casey Johnson, hereinafter Prosecutor 2, as collective members of /4 State of Michigan are in violation of the Codified Law of Nations, Book 1 of Nations Considered in Themselves, Chapter 12 of Religion and Piety, Section 130, when there is yet no established religion. Claimant's credentials as evidence of claimant's conscientious decision to retire from the U.S. government and states and foreign status prior to actions by the people. Claimant hereby charges that the defendants are in violation of ICCPR Article 11.2 by denying claimant the right of having retired from the U.S. government and states thereof prior to the actions. So, you're he's suing them in federal court for on it. His cause of action is a violation of the law of nations, the ICCPR. That's his cause of action. It's not going to get that far, but can anyone say 12b6? Okay, I've got to move on. I can't do more of the claims. Well, no, this one might be good. Claim 4. Claimant hereby charges that the defendants are in violation of the codified law of nations, Book 1 of Nations, considered in themselves, Chapter 10 of Money and Exchanges, Section 106, duty of the nation or prince with respect to the coin for initiating a bond upon PMA and or claimant foreign to the U.S. government and states thereof, as surety to be invested on the World Stock Exchange of the world to bring fiat currency into existence renounced by claimant prior to actions by the defendants. So, in all my time studying finance, let's ignore my JD, but I have a bachelor's in finance and I have a master's in finance. Never one have I heard of the World Stock Exchange. But hey. Oh, apparently St. Joe County violated the just causes for war, because war can only be undertaken with very cogent reasons, and war is unjust wherein deputy arbitrarily declared claimant a sovereign citizen. So calling Mr. Jensen a sovereign citizen is a declaration of war. Claimant hereby charges that deputy has violated ICCPR Article 20.2 for inciting discrimination, hostility, and or violence upon a peaceful civilian, wherein deputy arbitrarily declared claimant a sovereign citizen for not providing a contract foreign to claimant's political contract and claimant's contract with Jesus. And now we get to damages incurred upon claimant. Claimant has been under constant restraint and bondage. Kinky. From procuring basic needs to maintain health, food, hygiene, and spirituality for claimant and claimant's loved ones since the actions by the defendants. Claimant has been restrained and in bondage from utilizing claimant's religious and uninhibited freedom of movement under threat of further apprehension, forced detainment. He means detention, because detainment is not a word in this sense, and further forced association by the defendants foreign to the reign of heavens, a set-apart place that claimant operates within. Claimant is under constant distress as aggression has been heightened for the arbitrary declaration by deputy. Other registered agents may now consider claimant as violent and life-threatening and act upon claimant with violence or mortality. The defendant's damages upon claimant have incurred personal damages upon claimant of a magnitude more than any valuation in fiat currency. You have damaged me by arresting me for driving without a license on the roads of the state of Michigan. You have damaged me more than all of the currency in the world. I'd say you can't make this shit up, but Mr. Jensen did. Therefore, relief. Claimant hereby demands relief from personal damages incurred upon claimant in the form of property assets turned over to claimant by the defendants. All property assets shall be classified as property within the reign of the heavens, a set apart place on earth, set apart from the Luciferian kingdoms of the world, including the crown and holy see, and claimant hereby demands relief in the form of overturning all previous cases and judgments related to a driver license against PMA's name and PMA's name stricken from all departments, associations, agencies, corporations, and all other entities of the Crown and Holy See, no longer subject to any actions or investments by the Crown and Holy See. Fun fact, even federal courts have no jurisdiction over the Crown or the Holy See. Those are separate sovereigns. Claimant hereby demands relief in the form of the return of international translation of national driver permit and passport issued by the Secretary of State for the Government of the United States of America, currently in possession by St. Joseph County Sheriff Deputy for St. Joseph County Sheriff's Department. This claim shall serve as further evidence for any claim demanding relief for damages incurred by the Crown upon one citizen of the reign of heavens, a set-apart place on earth, and claimant hereby gives thanks to God of Abraham, Isaac, and Jacob, and praise to Jesus for peace and reconciliation with all persons, for may they be given eyes to see and ears to hear Jesus' words and teachings. Claimant further saith not. Kirk Edwin. Signature, Kirk Edwin, citizen of the reign of heavens, a set-apart place on earth, this 109th day in the year of Yahweh, 6025, translated the 6th day of July in the 2023rd year of the new covenant in Yeshua's name. Wow. Just wow. And email communication is preferable. Okay, so that's the end of that document. So I don't remember which exhibits are which, so this one looks fun. Constitution for the Reign of Heavens. Preamble. We, the reign citizens of the reign of the heavens, hereby acknowledge the existence of the Messiah and King, God, the Messiah, Yeshua, Jesus, the Christ, hereinafter the sovereign, and recognize the reign of the heavens is the body of Christ and the Spirit of Christ. The reign citizens recognize that the sovereign has been given all the power that is in heaven and earth. Matthew 28:18. We see the sovereign of sovereigns as the chief cornerstone that the builders have rejected. However, the reign citizens do not reject the chief cornerstone. I realize it's religious, but all I think is Bob Marley / Sublime, this train, you know, the stone that the builder refused, shall be the chief cornerstone. So I'm going to have the headcanon that Mr. Jensen is a Bob Marley fan. So the name and style of this assembly shall be Assembly of Elohim. Social compact. I hereby and accept that Jesus is the Messiah, Yeshua, Jesus, the Christ, as King, Savior, and Messiah. And I hereby and accept and declare that my Messiah and King is the Son of Yahweh, that he died for my sins and was resurrected in 3 days after his death. For Elohim so loved the world, he gave his son, blah, 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 metes and bounds of the reign of heaven. This one's going to be important. The reign of the heavens is a people and not a place. The reign of the heavens shares the metes and bounds of the United States of America. All exiles from the United States of America are not to return, nor come to the reign of the heavens, nor back to the United States of America. Yet, the reign of the heavens is a people and not a place. Yet they demand the usage of the roads of the state of Michigan that were built by the state of Michigan, paid for by the people of the state of Michigan. But these people deserve to use them for free without restriction. That's offensive. So and the signatories, I'm done reading the Constitution, but the signatories are Deborah Kathleen Davidson, Kirk Edwin Jensen, Marshall Revlin Rinkenberger, Derek William Davidson, Gregory Thomas Johnson, Trent Winsley Saylor, Kevin Michael Juhas, Frederick George Sykes Jr., William Ralph Davidson, Kevin Lloyd Lakes, and Naomi Ruth Spears. I wonder if this is a different reign kingdom than the one Kim Blandino belongs to. Or if it's the same and Kirk Edwin Jensen is just a much higher level as a signer of the Constitution. Kim Blandino only wishes he could sign the Constitution of the Kingdom of Reign on Earth. All right, what does Exhibit 3 have for us? Ooh, it's his oath. I, the undersigned, hereby declare with this oath that I absolutely and entirely renounce and abjure all allegiance and fidelity to any of the kingdoms of the world and all their glory, ruled by Lucifer under the creed of Luciferianism or Luciferianism or various doctrines and the religion of Satanism, its potentates, its states, its sovereignties, its regions and principalities, of whom or which I have heretofore been assumed to be a subject or citizen thereof. So help me God / Yahweh, Kirk Edwin Jensen, signed Kirk E. Jensen. Wasn't that one fun? The political affiliation declaration. Yeah, I don't care about that one. Summons. So these are exhibits 8 and 9 combined into one because the clerk made a mistake, but that's okay. But the U.S. national debt, $32 trillion, which is actually quite misleading. I don't know what it really is, but it's an accounting trick. And the Michigan state debt is $625 billion. Notice to appear. Okay, where was it? Let's find it. There it is. Blow it up. It's terrible quality. I apologize. It's a scan. Well, it's a copy uploaded as a scan, but ID Kirk Edwin Jensen, PMA, the United States of America, global something or other. Yeah, I can't read it, but it's there. And international translation of driving permit categories: A, motorcycle, A1. You know, it's just a picture. I'd be interested if someone were to scan that QR code, if the resolution is even good enough. I'm not going to do it. A1, and B is what he's claiming. So he can ride motorcycles, mopeds, and cars, but he can't drive box vans or trucks or buses, or that looks like a trolley maybe, or trailers, or a bus with a trailer, I guess. Wasn't that fun? But there's more. We have what is taken by the court as a motion for permission to proceed in forma pauperis, basically saying, I'm broke, don't make me pay the $402 filing fee. So comes now Kirk Jensen, blah, blah, blah. Claimant recognizes that one or more of the persons charged, blah, blah, blah. Basically, the gist of it is right here. Claimant hereby gives thanks to God of Abraham, Isaac, and Jacob, and praise to Jesus for peace and reconciliation through relief of damages incurred upon claimant, free of any charges or fees while seeking relief, thereby waiving any applied fees upon claimant. Claimant further saith not. So basically, the court took this as an application to proceed in forma pauperis, which the court said, hey, you didn't provide us enough information because we need your financial information. We need the actual financial affidavit saying that you are broke. And so he actually did provide that. It was referred to a magistrate. And because the motion to proceed in forma pauperis was granted, the court got to basically say, this is frivolous right away. So let's take a peek at the magistrate judge's report and recommendation that the action be dismissed with prejudice for failure to state a claim. So this one will be fun. So the report and recommendation. Plaintiff Kirk Edwin Jensen, who identifies himself as a reign citizen within the reign of the heavens, but resides here on earth in the state of Illinois, initiated this action on July 13th, 2023, by filing a complaint against certain unknown parties. Having granted plaintiff's motion to proceed as a pauper, I have conducted an initial review of the complaint pursuant to 28 U.S.C. section 1915 E2 to determine whether it is frivolous or malicious, fails to state a claim upon which relief can be granted, or seeks monetary relief against a defendant who is immune from such relief. Having conducted this initial review, I recommend that plaintiff's complaint be dismissed because it fails to state a claim upon which relief can be granted, and it's frivolous. Pursuant to Federal Rule of Civil Procedure 12b-6, a claim must be dismissed for failure to state a claim on which relief may be granted, unless the factual allegations are enough to raise a right to relief above the speculative level on the assumption that all of the complaint's allegations are true. That's from our dear old friend Twombly. As the Supreme Court has held, to satisfy this rule, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. And that's from Twombly's twin, Iqbal. This plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility that a defendant has acted unlawfully. If the complaint simply pleads facts that are merely consistent with a defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. As the court further observed, two working principles underlie our decision in Twombly. First, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions, as we have seen from Delete Law's many misstatements of the law, because legal conclusions don't have to be taken as true. Conclusory statements don't have to be taken as true. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Rule 8, the rule for pleading, basically, it says you need a short and plain statement of the cause of action and the facts, blah, blah, blah. Rule 8 marks a notable and generous departure from the hyper-technical code pleading regime of a prior era, but it does not unlock the doors of discovery for a plaintiff armed with nothing more than conclusions. Second, only a complaint that states a plausible claim for relief survives a motion to dismiss. Determining whether a complaint states a plausible claim for relief will, as the Court of Appeals observed, be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. But where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, the complaint has alleged, but it has not shown that pleader is entitled to relief. And that was a long block quotation from Iqbal. Because plaintiff is proceeding pro se, the court must construe his pleading more liberally than it does for pleadings drafted by lawyers. But this liberal pleading standard is not without its limits and does not abrogate basic pleading essentials in pro se suits. Stated differently, liberal construction does not require a court to conjure allegations on a litigant's behalf. To require otherwise would not only strain judicial resources, but would also transform the district court from its legitimate advisory role to the improper role of an advocate seeking out the strongest arguments and most successful strategies for a party. Plaintiff's complaint fails to state a claim under the foregoing pleading standards, even with due regard to his pro se status. A cursory review of the complaint demonstrates that, rather than a good faith and sincere effort to invoke this court's jurisdiction seeking relief for a legally recognized wrong, the complaint is indecipherable and filed for some improper purpose, as demonstrated by the following opening paragraph, which we already looked at. The remainder of the complaint contains similar cryptic statements. Based on the attached exhibits, the complaint appears to be a response to criminal charges for operating a motor vehicle without a valid license and no proof of insurance in St. Joseph County, Michigan. Plaintiff appears to claim to be a sovereign citizen, not of this earth, and not subject to the jurisdiction of the United States, any state, or any political subdivision. In any event, the complaint fails to state a cognizable claim against anyone. The complaint must also be dismissed where it lacks an arguable basis either in fact or in law, and it lacks an arguable rational basis in fact if it describes fantastic or delusional scenarios. The instant complaint clearly meets this standard. Kirk Edwin Jensen's complaint is fantastic or delusional. Boom, to quote Juan Galt. Boom. Conclusion. For the foregoing reasons, I recommend that the court dismiss plaintiff's complaint with prejudice for failure to state a claim. The court must also decide whether an appeal of this action would be in good faith within the meaning of 28 U.S.C. Section 1915A3. Good faith is judged objectively, and an appeal is not taken in good faith if the issue presented is frivolous, defined as lacking an arguable basis either in fact or law. For the same reasons that I recommend dismissal of the action, I discern no good faith basis for an appeal and recommend that, should plaintiff appeal this decision, the court assess a $505 appellate filing fee pursuant to Section 1915B1. Wow. So basically the court saying this nonsense is so frivolous, so lacking in any merit whatsoever that if Mr. Jensen wants to appeal this dismissal, even though the court granted him leave to file the lawsuit in form of pauperis, so without a filing fee, in spite of all that, this is so frivolous. If he wants to appeal, he's got to pay $505. That's essentially slamming the door shut on him. Wow. That was wonderful. Of course, that's not the end of it. We have his objection. And he objects. Yeah, it's just the same nonsense. I'm not going to make it through that. You can look it up on Court Listener if you want to. But either way, the judge, because the magistrate recommended dismissal, but the judge has to dismiss. So on August 25th, the judge dismissed. It's gone. So when, remember I said way back in the video, when Mr. Jensen put emphasis on there is a federal court case, you are a defendant, blah, blah, blah. Well, that was on August 28th, if I remember. It was dismissed on August 25th. So by the time Judge Middleton even knew about it, it was dismissed. End of story. Bye-bye. Thanks for playing. So with that, that's the only video I'm recording today because, frankly, I don't feel well, but this one was just too much fun, and I was happy that my Utes won. So hopefully I'll get more recorded tomorrow so that I can extend my streak of consecutive days of uploading videos. But with that, please like, share, subscribe, do all the fun YouTube-y things, and I will see you very soon for the next one. Boy, this one was fun. And bye-bye.